Julie, we have motive, means, and opportunity here. The motive is to kill a witness in his court-martial case. The means, of course, that's that cell site data that's been subject to the defense motion and dismiss the indictment. That puts Martin at the scene of the murders. And the opportunity is that shell casing. Obviously, some sloppy police investigation there. We know the defense is going to go after law enforcement hard in this case, but that shell casing does match a firearm that was seized from Martin's home.
This case is going to be an interesting one, prosecutorial perspective. We know this is a defendant who probably has a big goose egg in terms of a criminal history because he's working as a pilot. He would have to be vetted in order to have such a job. We know he's also a veteran. He served our country. There are some good facts there. Not much, if anything, that a prosecutor could really go after if he takes the stand. Your thoughts on whether or not he might testify, and if he does, what might the prosecution do on cross, please?
Julie, first, I agree with you. My heart goes out to the victim's son, and I have to give him credit. I mean, the reason this case is being prosecuted is because he particularly advocated and got the Kentucky Attorney General involved and essentially reopened this case. But to the extent that Kit Martin testifies here, I agree with Daryl. It's going to be potentially problematic. It's going to open the door to cross-examination that we prosecutors absolutely love. Things like him downloading that classified material, that kill list. This is someone that's arguably something that's an act of dishonesty, and then potentially the physical and sexual abuse of those minors as well. So I think if you're the defense, you want to play this straight up. You're going to go after law enforcement, go after the investigation, really attack that cell phone evidence, which they're already doing in their defense motions. By putting your client on the stand, despite him being a decorated veteran, a commercial airline pilot, you're really opening the door to a lot of potential problems. So I don't see it happening here.
Appreciate your thoughts. 5 months. That is the projection in terms of the amount of time. I think that is insane. Neama, what do you think about that amount of time projected for this case?
Julie, I got to defend my hometown of Los Angeles here. We are the jurisdiction that are taking Robert Durst to trial when New York didn't and Texas was unable to get a conviction. So,
I hear you. Good on your hometown for that. Absolutely.
But I agree with Daryl. This is a tough circumstantial case. Really, the only direct evidence against Bob Durst relating to the death of Susan Berman is his admissions at the end of the jinx and that cadaver note. So John Lewin and the LA County District Attorney's Office, they have to piece together this very long circumstantial case that's going to last months. It's really the only way to try this case and to dirty up Bob Durst, show the jury that he's abusive, he's violent, and he had every motive to do this. Otherwise, you're not going to be able to get a conviction. Let's not forget what happened down in Houston when this same defense team, Dick DeGuer and Chip Lewis, these guys, they were able to get a full acquittal on the murder charge based on that self-defense theory, even though Durst admitted to chopping up his neighbor and throwing him in the ocean.
It's absolutely incredible to me. I wish I could have watched that trial. Neama, what did you think of that little line of questioning in the cross-examination? Was it effective at attempting to show the jury that he possibly was influenced by the producers of the jinx?
Julie, I loved it until the very end. Actually, the part we didn't see. I happened to see this testimony live, and I thought DeGuerin did a good job going after Mayer, showing the jury that he spoke to everyone except the defense. But he broke the cardinal rule of cross-examination. And he's one of the best, but he really took it too far, tried to gild the lily here, and he asked the one question too far, which allowed Mayer to say, whoa, 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 you called me defense attorney, but you called me at 9 p.m. while I was having dinner. You didn't let me know who you were, and had you done that, I probably would have spoken to you. So I don't want you to tell this jury that I only wanted to talk to the prosecution and the media.
Yeah, I'm so glad you made that point, Neama, because it's true. You gentlemen both know this. You're both sensational trial attorneys, very seasoned. And, sometimes when you're feeling so good in a cross-examination, you need to know when to sit down and not go a little too far. Sometimes it's so tempting to just ask one more question and then you get things handed to you. So we shall see when things resume. We've had some heated moments, as you both know, in this trial. With me, criminal defense attorney and former prosecutor Daryl Cohen, standing by in Atlanta, Georgia. And with us, former federal prosecutor, trial attorney Neama Rahmani in Los Angeles, California, where the Durst case is happening. Neema, I want to go to you first. Give me your assessment of how Ruth handled herself on the stand there, and tell me what you may have liked or not liked in terms of the direct and the little bit of cross that we played, please.
Julie, I liked her as a witness. I thought she was good. She got out some of the violence issues, right? And we know that if the state is going to win this case, it's because the jury does not like Bob Durst. That's why they spent so much time on the domestic violence and other issues like him getting food stamps and being a shoplifter and those types of things, because they need to paint a story for this jury that they're not going to like Bob Durst, and that's why they should convict him. Some things that she said that I didn't like, and some of the state witnesses have had this problem. They've overextended themselves a bit in terms of, speculation and those types of things, trying to draw the conclusion that Bob Durst did this. And because some of these witnesses, many of which, not these folks, but they're professionals, they're physicians, they're not used to this type of cross-examination, and they put themselves in a corner where they're dealing with some of the best defense attorneys in the country, and they've gotten beat up a little bit on cross-examination.
I hear what you're saying, and we're just getting